Good afternoon, and thank you very much. Let me extend my appreciation to Sophie and Veld and the hosts of this meeting. I appreciate the opportunity, of course, to share my perspective on competition and privacy in data markets, an issue that I have thought about and I've written about a great deal. Now, my interest in privacy and competition began when I was a commissioner at the Federal Trade Commission. Currently, though, I am a partner, as you heard, at the law firm of Fulbright and Jaworski, where I represent a number of clients in the technology sector, including Microsoft Corporation. But my interests in these topics really predate my representations, and they do not necessarily reflect the views of my current clients. But in 2007, as a sitting commissioner, I dissented from the FTC's decision to unconditionally allow the merger between Google and DoubleClick to go forward. And I believed that the impact of privacy should have been considered in the competition analysis, as well as the possibility of markets for consumer data. Now, it has been almost 5 years since I authored the dissent, and I believe that the nexus between privacy and competition is more evident today. In my view, this nexus will become even more important in the future because of 4 trends that I believe we will see. First, user data, including personal data, is becoming an increasingly important asset for many businesses. Last year, the World Economic Forum called personal data the new oil, and it called it a valuable resource of the 21st century, predicting that it would emerge as a new asset class touching all aspects of society. Second, major internet companies increasingly compete in multiple product and service markets, which gives them more opportunity to collect data in different settings. So I expect that we will see businesses generating both more detailed and more holistic profiles of their users than ever before. In many cases, these user profiles will be controlled by firms that have already achieved dominance in one or more markets. And some of these firms might also seek to use their control over user data to solidify their dominance or expand into new markets. And then third, the shift to mobile computing is giving firms new location-based data streams that they are integrating into user profiles and also exploiting in real time to provide targeted location-based advertising. But there is evidence that mobile consumers often are not presented with either meaningful notice or choice regarding this data collection. And the collection and exploitation of location-based data could present regulators with a new set of challenges. And then the fourth trend, large firms that collect data are seeking new ways to monetize this data, including ways that potentially reinforce their dominance. A firm that achieves market dominance might not face competitive pressures that would prevent the firm from using data in ways that invade consumers' privacy, potentially foreclose competitive threats, or otherwise harm consumer interests. But in order to stay within my time frame, let me just provide you with just a few recent examples of the nexus between privacy and competition. Just last month, the Article 29 Working Party sent a letter to Google on its privacy policy changes. And although the Working Party did not make formal findings about the company's market power or dominance, it did suggest that Google's large market share was relevant in evaluating whether the new privacy policy created risks to consumer privacy. Also, the European consumer organization, BUC, recently expressed similar concerns about the privacy policy and stated that it is directly linked to the company's dominance in online search. And then with respect to the DoubleClick merger that we've spoken about today, it took place in the Commission in 2007 in December. While the European Commission did not focus on customer privacy in its review of the DoubleClick merger, it did consider this issue in the TomTom Teleatlas case that was decided soon thereafter. TomTom is the European market leader in software for personal navigation devices that use GPS technology. TomTom proposed to acquire Teleatlas, one of only two providers of digital maps with complete coverage of Europe and North America. Consumer privacy was a part of the competitive analysis of that proposed acquisition. So these cases certainly suggest a growing sensitivity to the nexus between privacy and competition. They also show, however, that a consensus has not yet been reached on how regulators should analyze this nexus. Now, in the brief time remaining for my remarks, I would like to provide an overview of three different theories on how issues of consumer privacy might fit within a competition law analysis. Now, although these issues are based on US legal theories and regimes, my understanding of European competition law leads me to believe that these could easily be adopted to European legal frameworks as well. So the first theory flows from the self-evident proposition that firms compete not only on price, but also on various non-price dimensions that are important to consumers and that may influence their purchasing decisions. Now, this concept is widely recognized in existing competition case law and economic theory, both in the United States and here in Europe. Similar to the US antitrust enforcers' 2010 horizontal merger guidelines, in the European Commission guidelines on horizontal mergers, market power is defined as the ability to profitably increase prices, reduce output, choice, or quality of goods and services, diminish innovation, or otherwise influence parameters of competition. Now, just as a firm that achieves a dominant position is likely to have reduced incentives to compete on price and on various non-price attributes, it may also have a reduced incentive to compete on the strength of privacy protections that it offers to consumers. And this seems particularly likely to the extent that weaker privacy protections, for example, through more intensive data collection and more intensive monetization of that data, provide the firm with opportunities to strengthen its market power and widen the gap between itself and its competitors. Dominant firms that lack incentives to compete on privacy protections offered to consumers may also have incentives to take other actions that potentially could foreclose competition or harm consumers, such as seeking to exclude competitors from opportunities to collect user data or develop competitive alternatives, or failing to be perhaps fully transparent with consumers about their practices. And then second, a closely related area where firms engage in privacy-related competition is in the development of business models and technologies designed to strengthen user privacy. Even today, we see examples of such innovations, although many of these reflect efforts by firms that are really trying to gain a foothold in a market in which a single player is dominant. For example, DuckDuckGo. DuckDuckGo is a search engine that promises no tracking. Search queries are not sent to other sites, and search histories and IP addresses are not saved. Now, interestingly, as I was preparing to come to Europe, last week in the newspaper, DuckDuckGo publicly announced it believes that it's being disadvantaged and shut out of the search market, and that it's being shut out of the Android mobile operating system. So it'll be very interesting to see if regulators will be looking into this as well. Another example is sGroupals. It is a social networking site that promises no spying, no tracking, and no stalking. Now, according to sGroupals, they claim that inside their site, no tracking of users occurs, no profiling, and no sharing of personal information. Another example, of course, is the Do Not Track feature in the internet browsers. And currently, they're grappling with this, with the opt-in, opt-out issue standard within the W3C International Consortium. So currently, of course, these alternative privacy-enhancing technologies are being offered by companies that, in my view, are really too small now to exert a material impact on consumer choice or competition. In a competitive market, companies compete to introduce business models and technological solutions that satisfy consumers' demand for privacy protections. A dominant firm might not have the same incentives to invest or invest as much or invest as quickly in adopting privacy-enhancing business practices or developing privacy-enhancing technologies if it feels confident that the lack of competitive alternatives for consumers gives those consumers higher tolerance for weaker privacy protections and technologies. And while I was a sitting commissioner, the FTC conducted an extensive study to understand how competition and patent law could promote innovation. And as the final report noted, it said that competition can drive innovation, and its power to do so may depend on market structure. The report went on to say that it is true that even a monopolist that faces no competition has an incentive to expand the demand for its products and to reduce its costs. However, the report went on to say some believe that a monopolist that does not face threat of entry has less incentives to engage in costly research and development to develop new products than does a firm that does not face competition. And then the third theory is as firms continue to develop new products and services based on new ways of monetizing databases of user data and or user profiles, competition regulators may need to consider defining a market for the data itself, not just a market for the products or services fueled by the data. Now, defining a market for user data may be unusual under traditional market definition principles, but it may better reflect how firms, how their competitors, and how their customers and users interact in the real world. A product market for data would also better account for the fact that firms are constantly finding new ways to use this data, far beyond the initial purposes for which the data originally was collected. These new uses often have important competitive consequences. For example, historical ticketing data, initially collected for the purpose of selling tickets to concert goers, is useful for concert promoters who need to decide which artists to book, when to schedule concerts, how to set prices, etc. A concert promoter who has access to this data will have a competitive advantage over a concert promoter who does not. Product market definitions based only on a snapshot of current data usage may not accurately capture this aspect of competition. So defining a market for user data may affect the structure and scope of a regulator's investigations. And if enforcement staff use compulsory process or subpoenas to obtain documents and information about a company's data, they will be in a better position to evaluate the potential uses for this data and access how the proposed merger will affect privacy practices. And let me end by talking for a second about remedies. When crafting remedies, competition regulators might want to consider the extent to which a dominant firm might be able to extend its monopoly through its control over user data and ensure that any remedies would address this potential risk. In many cases, these remedies would promote the goals of both competition and consumer protection law. After all, these laws do have complementary goals. Competition law strives to ensure that consumers have a range of choices, while consumer protection law seeks to ensure that consumers have truthful and accurate information when making those choices. Thank you very much, and I look forward to exploring these topics with my fellow panelists.